So before our panel session, our final speaker this morning is Matthew Herder. Matthew is an assistant professor in the Department of Bioethics, the Faculty of Medicine at Dalhousie University. Matthew holds LLM and LLB degrees from Dalhousie University and a Master of the Science of Law degree from Stanford. He's been a research fellow at New York University and has taught at Loyola University in Chicago. Given Matthew's interest in how funding arrangements, IP rights, and entrepreneurial activities influence scientific knowledge generation, he'll speak to us about legal issues facing gene discovery research and share some reflections on the Prometheus case. Matthew, welcome.
I'm actually going to focus exclusively on one issue that I think potentially will have a dramatic impact on this area of research as well as others. And I think it's really important to take this into account when I'm thinking more broadly about orphan disease policy in Canada, because in the early 1980s, when the US enacted legislation, patent law looked very different than it did up until about March 19th of this year. The 20th of March is when the Supreme Court in the United States released its unanimous opinion. Justice Breyer authored the decision in a case called Prometheus versus Mayo Laboratories. And so there's a lot of conversation about this right now. And you're going to see quite a polarized conversation, right? So if you were to pull out a quote from the web, the American Medical Association characterizes this as an extremely important and beneficial decision. And as you might expect, bio and industry groups have said very different things. Some have raised very dire predictions for the future of personalized medicine in particular. So there's a lot of concern and polemic around this case and what impact it will really have. So I don't want to assume too much knowledge or really any knowledge around patent law, so I'm going to spend a little time at the start giving you some basics around patent law. And then I'm going to focus on the Prometheus decision itself, what was said by the court, and then try and extrapolate from that and think about what this means going forward. Along the way, you'll notice that I'm going to draw three different distinctions. So as I get into the case itself, I'm going to talk about this distinction in law between laws of nature, natural phenomena, abstract ideas, and the application of those things, which is quite important when you're considering whether something is eligible for patenting. Then I'm going to talk a little bit about some empirical evidence quickly in passing around the importance of patents to commercializing or even for discoveries in the first place. And then conclude with a distinction in the group of implications that I think this Prometheus raises, and thinking about gene patenting in particular, or markers, and try to explore whether there's a difference between the kind of biological relationship that was at issue in Prometheus versus, say, gene patents, which are in a case which the Supreme Court may soon hear in the United States as well, called Myriad, with respect to the BRCA genes. So just getting going on some basics, what is a patent? If I was teaching my patent law class up the street, I would say it's a bundle of rights. That's the metaphor we like to use, or a bundle of sticks. There are a variety of rights that if you actually get a patent, you have. You have the exclusive right to sell, to make, to use, to offer for sale, sometimes import, export, and to contract with someone else to give them permission to use part or some of those rights, or all of them in some cases, if you so choose, right? So that's just a basic frame of what a patent is. It's a package of exclusive rights. To get a patent, though, you actually have to get over several different hurdles. And this is literally the slide I use in my patent law class. And I talk about these different requirements in a very clean and neat way. So I say, to get a patent, you have to come up with something that is new, it's novel, it's non-obvious, and this is probably the most tricky standard. That means that it's, in Europe, this would be referred to as the inventive step. So an invention has to be inventive, pretty circular, leave it to lawyers. But what that means is if you were a person who was skilled and well-versed in the art of a particular technology, you would be presumed to be aware of a lot of the literature, and you could synthesize that literature to some extent. And if by virtue of that synthesis, you would think that this invention is obvious to someone who has that basic level of skill, then it's not a patentable thing. It has to exceed that. It has to be non-obvious. Thirdly, it has to be useful. This is actually a fairly low threshold. And then there are a bunch of other requirements that are around disclosure. So what do you have to tell the world in your patent application about what you've invented? But prior to that, there's this threshold question, or this is how I like to conceptualize it for students, about whether it's patentable subject matter in the first place, right? So is this something that Congress, the courts over time have basically just said, we want to remove from the basket, even if it would meet the requirements of novelty, non-obviousness, the written disclosure, utility, and so on, right? So there's this preceding question about whether it's patentable subject matter in the first place. And in different countries, this threshold question plays out a bit differently. The one that there's a lot of agreement are these sort of laws of nature, natural phenomena, so or abstract ideas like Einstein's E = mc squared. That's the one that the court used because it loves to quote it, simple and easy. Laws of gravity, Newton kind of stuff. And then there's more variation around the world around medical methods. The US has a sort of very narrow exception from patentable subject matter for medical procedures, surgeries, and so on. Whereas I would say in Canada and Europe, this exemption is a bit more robust, and that's a long, complicated historical story. In Canada, although some people think this is not the law anymore, in 2002, our Supreme Court decided that higher life forms, even when they've been genetically modified, if you try and claim the actual organism as a whole, we're not going to allow a patent on that kind of thing. And Parliament needs to change the law if we want to go down that path. There's a subsequent case that really complicates that as an interpretation of where we are. However, it's just the basic point I want to make is there's this threshold question of is it in the basket or not of things that we could patent before these other standards of novelty and non-obviousness. And when I get into the implications, part of that will be the legal implications or the implications for people trying to file patents, and this gets messier because of the Prometheus decision. Conceptually. A lot messier than it already was. So I'll just skip over this quickly, but the current controversy, I think it's important to remember that there's a really long history about what is the scope of patentable subject matter. Things shifted, some would say, in favor of opening up the range of patentable subject matter following Cohen-Boyer and recombinant DNA technology. There was a decision known as Diamond versus Chakrabarty, which involved a genetically modified bacteria, and the Supreme Court, quoting from a report from Congress in the 50s, said anything under the sun that is made by man, so there's human intervention, even if it seems to exist in nature, if it's been modified, tweaked, or made available maybe, that is potentially patentable. There's actually a much older set of cases that do similar things. The Park-Davis case involved adrenaline. Interestingly, that's become very famous because the judge who decided that was second year on the bench, learned hand, and he just completely missed a case that might have left him or led him to a different conclusion. But a lot of people cite that case as indicative of if you isolate or purify something, so adrenaline exists in the human body, but making it available to all of us by isolating and purifying and figuring how to extract it, that can be sufficient to be in the realm of patentable subject matter. So that's a very old decision. And there are older ones that are relevant. So this is Prometheus. The pendulum has gone back and forth over time, and it's certainly switching back towards the direction of making it harder to be eligible to qualify for patent protection. So I'm getting into the decision itself now, and I want to just put on the board the actual claims that were at issue. So a patent, remember, is the set of exclusive rights, but the scope of a patent is defined by the claims, which are literally just enumerated lines in the patent application which try to spell out some of the boundaries of the invention. And the patent claim at issue in Prometheus was essentially 3 steps, right? Administer a drug, determine the amount of metabolites in the patient's blood after administering that drug, and make an inference about drug dosage based on the correlation that you find between the metabolites and what's going on inside the person. At the time of these discoveries, scientists understood that there was a correlation between these metabolites in the patient's blood and whether a particular dosage of the drug, a thiopurine drug, could cause harm or prove effective, right? So there was, this knowledge already existed, right, at the time that they filed for these patents. But they didn't know how the precise correlations, right? So, and this patent actually goes on to talk about what those correlations should exactly look like. If you're within this range, then you want to stop treatment, or this dosage would be appropriate, and so on. So this is where the first distinction I want to draw becomes important. Is this a law of nature? You've got this relationship between a drug that's been administered to a patient and how it's being metabolized in the body. Is this a law of nature, or is this an application of a particular law of nature? The answer that the court came up with is that this is not patentable subject matter. It is a law of nature. And it's sort of a three-step reasoning process that they followed. The first, they said, well, sure, there was human intervention. Someone gave this patient or a patient the drug. But after giving them that drug, it's a manifestation. What goes on in the body is happening solely because the body's natural processes, right? So they basically minimize the importance of having given the drug in the first place. They said that wasn't sufficient to take this realm out of the sort of natural phenomena. Then they asked a particular question, and I think the importance of this will become clear as I go on. And they say, do these steps that are outlined, administer the drug, monitor what level of metabolites are present in the blood, and then make a decision based on the correlation, does that do significantly more than simply describe what's going on within the body? You can't simply recite a law of nature, the court said, and then say apply it. Right? So Einstein couldn't gotten around this rule against patenting laws of nature by saying apply E equals mc squared in this technology. The third point, and this is just as important as the second in my view, the court talked about whether what the steps that were outlined in this process, whether they were routine, well understood, conventional within the field, within medicine, people who would have been making these decisions in conjunction with patients. And they found, as a matter of fact, that they were well understood, they were routine, they were conventional. So they were concerned about allowing a monopoly on something that's already, it seems, part of practice. Now, the patent provided more precision in this decision-making, but it didn't take us in a different direction, for example. So this slide, I'm just sort of emphasizing the point I just made. They found that in this particular case, these were well-understood routine steps that physicians would have followed already before this patent application was filed. And they made an assumption, and this was heavily contested at the various stages in which this was litigated. And they said, in that situation, we're really worried about limiting future innovation. Mayo had actually developed a test that differed slightly from the one that Prometheus had patented, and it was for that reason that this litigation ensued. And the court was sort of worried about people who want to tinker and add to and improve upon that initial test. And they specifically said, we think this is going to tie up the doctor's decision, their treatment decisions, and threaten to develop the more refined treatment tests and recommendations using this kind of technology. That's a big assumption, right? A lot of people, if you read the judgment, Prometheus was saying the exact opposite. So were various friends of the court were saying, we need these patents to develop, to have an incentive to do this kind of work, to develop these technologies. And without them, these technologies won't come down the pipe in the future. On the other side of the equation, there was the American Medical Association, various other friends of the court and organizations who said the exact opposite. This is going to slow things down. This is going to have a chilling effect on research and hurt medical practice. And that's where the second distinction around what evidence do we actually have around how critical these patents are to having these discoveries take place in the first place and then having them commercialized. So you have a basic relationship that you find, but you have to do extra work, say, to get approval from the FDA and so on. Our patent's quite critical to that. With respect to the ex ante incentive, so do we need them to get these kinds of findings in the first place? I would say that the empirical evidence that is actually weak at best because of other incentives that are out there. A lot of those findings are discovered in the university environment, and there are grants, publication imperatives, other incentives that encourage this kind of activity. And it's not clear, but based on various economists' work, that we need patents to get those discoveries to occur at all. What there is stronger evidence for is to do the follow-on work to make sure that those findings actually have a lot of validity, and if they're bundled in with a drug or some kind of diagnostic device, to get them through regulatory approval. Those patents seem to be much stronger. There was a recent study done by Laurie Pressman of MIT, who was the former technology transfer office, I think, director at MIT, who showed that patents tend to be licensed faster when they come from academic institutions in contrast to the NIH. And that's in part because there are less strings attached often when they're coming from the university environment as opposed to the National Institutes of Health. So there seems to be some evidence for commercialization happening faster because of the existence of these rights. But again, it's really complicated. Mark Lemley in the United States, a really well-known intellectual property scholar, has pointed out that it's not clear that we get the best technologies because of the exclusivity. Open market competition might be favorable. Heavily contested claims, right? So Justice Breyer in the Supreme Court decision actually said courts are really bad at figuring that stuff out. There's a wealth of economic evidence. We're hearing diametrically opposed things from these parties around whether these patents are necessary, good or bad after the fact. And courts are pretty bad judges of this. Congress should think about it. But I'm still going to make the assumption that this kind of patent, in particular, limits future innovation because it doesn't seem to us that there's been much that's added to what physicians are already practicing or what was already in the published and patent literature. A lot of what Prometheus built up into its, or integrated in its technology was actually patented previously. It wasn't just published and known. So what are the implications of this? I'll sort of try to clue up relatively quickly. Am I doing okay for time? Must have a bit of cushion. Okay. So the first implications I'd like to think about are sort of doctrinal, the legal implications. In distinguishing laws from nature, the court was really focused on, as I've already said, is there something new here? Is there an inventive concept that is part of this, the application of a law of nature, something beyond the sum of its parts? Well, this sounds a lot. If any lawyers are in the room, you'll realize that this sounds a lot like other requirements in the Patent Act. So remember early on I said that you have to have something that's novel, it's non-obvious. This is the kind of language that's used there. And so to a lawyer, this looks quite muddy, right? You're actually building in other requirements into the threshold question. And if that's the case, what's the purpose of having them elsewhere in the statute? So a lot of people are worried about conceptually what does this mean if I have to, in effect, establish the novelty of an invention at multiple stages or in relation to multiple aspects of the patent statute. So there's a lot of confusion and unrest in the patent bar in particular about when I'm prosecuting a patent with the patent office, am I going to have to go over novelty and non-obviousness multiple times? And how hard is it going to be established that, both for the purposes of patentable subject matter and then for novelty itself, and non-obviousness and so on. So that sort of bleeds into the second set of implications around the practice of filing for patents. And the language in the case, I think, is problematic. But if you understand the underlying concern in a different way than the language immediately betrays, Justice Breyer talked about, we're really worried about laws of nature, application thereof. Lawyers are really good at drafting around and making a law of nature look like an application thereof. So we know that's a concern, and so that drove the court to this particular decision, I would argue. So if you think about patentable subject matter, it's under Section 101 of the Patent Act in the United States as a test about overclaiming, right? So is the inventor trying to say, I should have exclusive rights to more than they actually invented? I think you might start to think about, and this could be beneficial in the longer term, more modesty in patent applications. If you talk to a patent agent, they're going to sort of take on an ethic or a responsibility of trying to expand your invention as much as possible, right? Because they want to read on and prevent infringement by others so as to increase the value of your invention. But that comes with costs as well, right? So it's harder for inventors, companies, anyone in the world to feel like they actually have freedom to operate because the claims of these patents are so ambiguous in the first place, right? They're trying to capture more often and anticipate technology which hasn't yet been made so that they can extract a rent later on. So if you understand some of this decision as being about, we're really worried about these claims of patents being too ambiguous, and over the long term, you sort of keep patent agents and drafters more honest about what the contribution actually is, it might be a good thing for a lot of people so that they have more certainty about when they're entering into a particular market or space that they're not infringing on others. It might also make the patent literature a lot more useful to people who read it, right? Because you would get a clear understanding of what people have actually contributed. There's some evidence which suggests academic scientists in particular are paying more attention to the patent literature, but I think that's not to learn from the patent literature, and that could be a much more useful exercise if we see some more modesty in the way patents are drafted. In the shorter term, I think, and I've had some sort of offline conversations about how technology transfer offices, people who are trying to strike deals at the university-industry interface, in the wake of Prometheus, are having more pressure or encountering more pressure from industry in terms of saying we need to have more secrecy, more confidentiality around the research that we're doing because we're not sure we can protect this in the wake of Prometheus. From my perspective, that raises a lot of concerns, not least because of a lot of this research is publicly funded, and I think there's a really strong ethical argument in making sure that it's accessible, the knowledge long before it's turned into a product. And so I think there's going to be increasing pressure in that deal-making context to ensure we don't give up too much or agree to a lot of secrecy because it's suddenly harder to file for patent protection on biomarkers. It's important, I think, when we're thinking about IGNITE in particular, to acknowledge that the court said that this doesn't take away from the ability to file patent claims on drugs that have been repurposed for a new use and so on. That's not an easy endeavor generally. It wasn't for Prometheus, and I don't think that changes afterwards. It's still difficult, but their findings don't change that, which is important. And I'll just conclude with probably the most controversial, but maybe the implication that you're most familiar with, by talking about what Prometheus will mean for the myriad case in respect of the BRCA genes. So March 20th, the Supreme Court released its opinion in Prometheus. March 26th, it vacated the decision by the Federal Circuit, so the court below it, in Myriad, and said reconsider, basically redecide the case you've just decided in light of our decision in Prometheus. So where we are right now is we're waiting for the Federal Circuit to have another hearing, release a new decision, which no matter who wins, it's probably going to be appealed to the Supreme Court again. And it'll be interesting to see what happens. The Federal Circuit, though, in the decision that was just disappeared by the Supreme Court, actually found that there were two kinds of claims. Some claims, which I'll show you in a second, were on actually the isolated gene sequences. The other claims were method claims. So they were about physicians or anyone who compares and analyzes a sequenced DNA sample from a patient compared to sort of standards for the mutation and so on, and determined whether they were at greater risk for developing breast or ovarian cancer. Those method claims were actually found to be ineligible for patent protection because they captured mental processes. So this this thought process that physicians would engage in by just basically comparing two results. And so that a lot of people think that's not going to come up again, but the patent claims that extend to the actual genetic sequences will. Those are very much at issue. And so I wanted to try and think about whether there's a difference in any way, whether scientific or legal, around the biological relationship that was claimed in Prometheus versus some kind of biomarker, a genetic mutation and so on that's captured in the myriad patents. On the one hand, in favor of an argument in favor of saying there might be a difference, in a case before Prometheus of about a year, the Supreme Court in the United States said, we don't want to adopt any categorical exemptions to patentable subject matter other than laws of nature. So a case called Bilski, which was about business method patents and hedge funds, they basically said, we're not going to say, as a rule, business methods aren't patented or patentable. Similarly, I don't think they're going to want to come to the conclusion that gene patents are never patentable, unless they say gene patents are always laws of nature, natural phenomena, and so on. So these were the claims. If you actually looked at just the first one, you would see it's basically just referring to an isolated strip of DNA. And there's not much more than that, right? So there's not a process. It's not tied into some novel process of isolating that genetic sequence. My understanding, and someone can correct me if I'm wrong, is that the process that was used to identify it, although long, arduous, labor-intensive, time-consuming, were very well-known processes. It was just really a race. And so if you think about the language that was used in the Prometheus decision, where they were looking for something added, an inventive concept that was part of the application of the law of nature, I think that's missing again. And for that reason, I actually think the patent claims around the genetic sequences in Myriad, whether at the federal circuit or if it goes up to the Supreme Court, I think they'll be found to be non-patentable subject matter. So I just wanted to close with a prediction. I think a patent claims that's framed in either of these two ways following Prometheus is going to be extremely hard to get patent protection on. If it was an assay or a biomarker that was used, not a known standard, you might be able to get patent protection on those kinds of things. Or if there's a novel process of isolating or characterizing a biomarker, that might still be patentable in my view, but otherwise I think it's going to be extremely difficult. And there are a lot of different takes on whether that's a good or a bad thing. Perhaps that'll come up in the questions, and I'll stop there.
Quick questions, and then we'll move right into the panel session. You can start us off.
Actually, with regards to obviousness, I was just chuckling because that third claim there was an oligonucleotide of sequence 15 long. And so 15 to the fourth is a little over 50,000. So considering that there are more than 50,000 patents out there, somebody could claim every oligonucleotide of sequence 15 under this by submitting 50,000 different patents. So to me, that seems obvious. Is that not?
That's so the legal construct that's used to figure out obviousness is this skilled person that I mentioned before. And there's a push, at least in the legal academy, to say that we should be much more realistic about what that skilled person can actually know. And in the United States, as a matter of law, there's sort of this, they really are a mythical sort of superhuman who's presumed to basically know everything. Now, how far they can go to sort of putting the information together and synthesizing it is a tougher issue. And that's where the scope of the claim in terms of 50,000 and so on, whether they could be assumed to integrate all of that knowledge, there might be a fight there. I think that's how that would play out. But the thing that I find, and I think patent agents or those engaged in patent prosecution are going to find very frustrating, is that they might have to engage in that battle more than once at the stage of patentable subject matter, and then again, there's a totally different section in the statute around obviousness.
And I was just curious, I mean, Prometheus was the case in the U.S. Supreme Court. How do different countries' rules and regulations affect your calculations here? And, with respect to laws here in Canada versus Europe, European Union, and the Far East?
Just in case it's not obvious, the reason why I'm focusing on U.S. patent laws, because it's a market-based right. So even in Canada, everyone wants to file in the US, or that's what the market they're thinking about first and foremost, and then probably other countries again before Canada, although as a matter of course we see a lot of filing here too by Canadian companies, inventors, etc. There's a really good article that just came out in Nature Biotech that looks at genetic sequences, whether they're isolated or not, mental processes used to compare them to existing standards. And basically the answers look a little bit different depending on a number of jurisdictions. But those are just interpretations of new cases and directives that there isn't a lot of clarity. And Prometheus, I'd say until that decision, there was the most clarity in the United States compared to Europe. There are some added layers that make it tricky in Europe for things. There's something called public morality in European patent law that essentially there's another venue that might preempt some of these things from being patented, although there's lots of patents in Europe as well. So I don't know if that helps. I can't remember the table, so I can't give you the conclusion on each of those things in different jurisdictions off the top of my head, but I'm happy to give you the paper.
Matthew, a terrific talk. We use 6TG and 6MP in oncology, and yeah, even with having a test that would tell us about how a patient is likely to respond to it and metabolize it, we know that it's imprecise. So it'll come back saying that they're a heterozygote, likely not to tolerate as well as someone who has complete wild type. Yet what we would do with that information is to try it and then use that information in conjunction with how the patient responds to make a decision about how to proceed. And so my question is, does the precision of that test in terms of telling you how to predict it's going to affect a particular individual play into whether or not this was patentable?
So I think potentially Prometheus would have been safe if they'd restricted the claims to the very precise correlations and tried to pair that with decision-making processes, although that's tricky because there is this rule against claiming abstract ideas and mental process. But part of the problem was the claims and the rest of the disclosure, and how you construe a patent is a complicated legal exercise of not just the literal wording, but understanding the rest of the specification as well in conjunction, and they interact. But part of the court was really frustrated because the claims didn't even say, if it is, you get this correlation, do this. It actually said, just think about it. And you may or may not change your treatment decision. So they were really, and this is again the sort of patent drafting issue I was trying to get at indirectly, they were really saying no matter what physicians do, including nothing, we own that, which is pretty dramatic. And it's because there are built-in incentives for those drafting the patent to try and widen the claims. And perhaps if they had been more modest, there would have been a trickier decision for the court, but they were really worried about getting standard of care and clinical judgment in a patent, and so maybe that's one end around following Prometheus that could be helpful.
More precision.
Yeah. In the claims themselves.
Okay, well, thank you again, Matthew, for, as Conrad said, an excellent presentation, a lot of material to cover in 25 minutes, and certainly some fascinating implications of the case, both in the short term and on the long term. So thank you again, Matthew.